few weeks. I'm talking about some of the murder cases that have gained national attention that we've all been talking about. And I'm not here to incite any kind of violence. I'm not here to create any kind of divisiveness. I'm just here to help some of us who have questions. I'm trying to help us connect the dots. I'm not a legal expert. I'm just a person who does research from time to time. I study certain things, especially current events. And I really enjoy being able to sometimes be able to just connect the dots. So I think what we have in this situation, we're talking about the latest case was the Kyle Rittenhouse murder trial. We noticed that in that trial, I want to point out that, of course, we know that he was found not guilty of the charges. And I'm going to connect the dots real quick, dating all the way back to the Trayvon Martin, George Zimmerman trial. We know, of course, what happened, and we know that George Zimmerman also was found not guilty. And then what we have after this happens so often is we get this emotional, this high-strung, knee-jerk reaction, and then we start protesting, we start tearing up buildings, tearing up businesses, burning up the Gucci store, and we have all of these problems that don't necessarily solve or even point to the issue, in my opinion. So I just wanted to just kind of pull some stuff out, connect some of the dots, and I'm gonna get out of your way. So what happens is, we noticed that in the Trayvon Martin trial with George Zimmerman, he was charged with first-degree murder. So what happens is, in the court case, we go to court, we're excited because he was actually charged. Once we get to court, all the evidence is laid out, and we all know from watching and seeing the information that we're getting on television, we see what we would normally consider to be a slam dunk trial, right? But what's not happening is we're not paying attention to the actual charge and how it relates to the evidence and how the court system works. There's a portion after all the evidence has been laid out, and the judge oftentimes, well, every time, the judge gives the jury instructions at the end of the trial, after the closing arguments have gone forward. And a lot of times we're excited about what the judge is doing. We're moved by the judge's personality, his antics. We have concerns about who the jury is, if it's too many white women, too many black men, just all of those things that we start trying to put together in a case that really have little to no bearing on the actual outcome of the case. And what I'm trying to point out is this. It doesn't matter who the jury was in that case, and it really doesn't matter much who the judge was in that case. What really matters is the charge, right? When you have a first-degree murder charge in the state of Florida, there's some stipulations and some statutes that go along with that charge. First, we all know that first-degree murder has something to do with premeditation. You have to have either planned to do it, you have to probably have some kind of relationship, a prior relationship with the victim, or you have to be in the commission of a crime when you encounter the victim. In the moments before a murder, you have to be in the commission of a crime. That's where they use carjacking, bank robbery, things like that, breaking and entering, things like that. So if I'm robbing a bank and you pop out, I gotta kill you because you could possibly be a witness. Carjacking, you won't let go of the car, you get shot, and now you have a first-degree murder because that person was in the commission of a crime already. In the case of George Zimmerman, Trayvon Martin, we didn't see that. And if we did see it, we couldn't quite nail it down, so we couldn't prove that. So trial goes on. George Zimmerman's sitting over there in the corner. He's smug, he's comfortable, he's not worried about it because he understands the charge and he knows the evidence. Everybody who goes into the courtroom has access to the evidence. It's called discovery. You know the evidence is being presented in the court. You know the charge. So he knows, and I can't imagine everybody else involved in the case doesn't know. I don't know how someone involved in this situation cannot know that the charge in itself will never fit the evidence. So if the evidence is a murder, but you charge him with a particular kind of murder. At the point and at the time that the judge gives the jury instructions, this has to come together. The first degree murder, all of those statutes involving first degree murder, premeditation, prior relationship, commission of a criminal act, all of that has to already be in place in order to make a first degree murder charge stick. And because we don't have any of that, we don't have first degree murder. We move forward in the charge in the case of Kyle Rittenhouse, the kid who goes to Wisconsin, I believe, and a couple people are killed and several people are injured. He's using the AR-15. And at the end of the day, what happens is he's charged with several charges. All of them that I saw when I did my research, all of those charges had first degree listed, right? First degree malicious wounding, first degree murder. It was probably 5 or 6 charges that I saw. I can't reach it right now. But all of those charges were on the level of first degree, which means in order for him to be found guilty of these charges, we have to still have the same statutes, the same questions have to be answered. So when the jury goes and they deliberate, the questions that they have to ask in the room, in the jury room, is this: do we have prior relationships? Do we have commission of crimes? Do we have intention? Do we have premeditation? So if none of these things are present, it's not a trial of whether or not he killed the people. It was never a trial of whether or not George Zimmerman killed Trayvon Martin. It was never a trial about whether or not Kyle Rittenhouse murdered people or killed people, right? It was never a trial about that. The trial is about the charge. Can we stick the evidence to the charge and fit the evidence to the charge? Because the judge's instructions always say the same thing. The judge's instructions are: you go in, you deliberate, and you make sure that you have the evidence to support the charge. If we don't have the evidence to support the charge, then what we have is the statement that Johnny Cochran used in the O.J. trial. When Johnny Cochran was playing with that glove, he made a statement. He says, "If it doesn't fit, you must acquit." Right? Now that was in jest, of course. We thought it was pretty exciting because it was basically theater at that time. So no matter what theater you see played out in the courtroom, what he was probably saying, I would probably guess, and much respect to the late Johnny Cochran, but I would probably suggest that he's probably made a statement of that kind several times if he's a defense attorney. He would have to be saying or making statements to the effect of, if the evidence does not fit the crime, or the charge rather, if the evidence does not fit the charge, then you must acquit. If it doesn't fit, you must acquit. So when we go in and we see this happen, we see this played out in several different cases, we get really upset and we start, we're seeing some crazy stuff happening. I'm a small business owner, so I don't want my business burned out. I don't want my doors kicked in and my windows broken. I don't want to protest to the level of the destruction of property. I think it's totally and 100% unnecessary. And I hear you when you're saying no justice, no peace. I get all of that. However, if there's going to be justice, then that justice has to be won at the level of where it begins. And in these situations, that justice begins with a prosecutor, because I believe it's a prosecutor that brings the charges. I believe sometimes you have a grand jury that looks at the evidence, they go through the evidence and say, yeah, looks like enough evidence to create a charge. So once we have enough evidence to create a charge, the prosecutor says, okay, I'm gonna charge. I'm gonna give it this kind of charge. So if there's a problem, the problem lies right there. Before you get into the courtroom, if the charge doesn't work for the evidence, then the dial needs to be changed somewhere in that area. Because once it gets into the courtroom, you have a charge, you have evidence, and if it's not gonna fit, then you're wasting your time burning buildings down and tearing up businesses and jumping through the Gucci store. It's not gonna make sense. It's not gonna make sense now, it's not gonna make sense 5 years from now and 10 years from now. So what has to happen, in my opinion, I've been asked this question several times over the last few weeks, so I decided to come out here and share my thoughts with you about it. And I hope this makes somebody, just, because everybody's woke these days, right? And I don't think it's a good idea to follow any bandwagon that's going to be counterproductive. And I think some of what I've been seeing is, in my opinion, totally counterproductive in terms of the way the protests have been going, in terms of the narrative that we've been hearing and seeing. And I love D.L. Hughley. He's one of my favorite entertainers. And I feel bad when I see you crying and making statements like the white boy's tears, the bleach that washes the blood of. I don't get any of that, because what I get is, no matter what he did in the courtroom, the charge didn't necessarily fit the evidence. So it's not necessarily how the court case goes. Sometimes it's just how the charge is laid out. That's usually the thing. Now, if you want to play any kind of a race card, we have on good authority that oftentimes an African American person or a Latino person, a black or brown person, can go into the court system and get several charges. Right? You can be indicted for several charges so that there's no wiggle room. Like, we're gonna get you on one of them. Something's gonna stick here, right? Because the evidence, if you don't get you there, we get you here. If we don't get you here, we get you there. If we don't get you here, we get you there. So we know that sometimes, that's what some of us have had to face, and a lot of times that's what the issue is. So just to change the narrative or shut it down totally, we have to look at that part of it. I think it's time that we take a look at what the charges are, how the charges are brought, how the evidence is laid out, so that we'll know going in. We'll know sometimes that if the charge isn't correct, we already can see what the outcome is going to be. We can see it. And I want to charge some of, I'm going to go out here on this one. I would like to charge some of our black African American leaders, the ones who have to know this stuff. I can't be the first person to come out and say this. I can't be the first person to know this much, and I don't know anything. I don't deal with the court system on any kind of regular basis. But in order to move people forward as a leader, we have to have the right information. If we're just going off of old information and behaving and marching and singing and dancing and shucking and jiving the same way that got very little done in the past, I think what we need now is probably legislation. What we need now is probably a move towards changing some of what is written in terms of laws. I think that is called legislation. Laws need to be changed, which means it has to happen in order to change this kind of narrative. We can march all day, but if we don't get somebody in there to help change laws and help and create an understanding of what we're all facing, you can take all the statutes the way you want. You can give all the holidays you want. You can do anything else you want to do. But a court case is fought and won actually before it starts. Most people who've ever been involved in a court case at almost any level, you kind of know, you have an idea of the outcome. Because those deals have been made prior to the opening arguments, to the opening statements. So by the time you get to the judge, it's not his fault. By the time you get to the jury, it's not their fault. Doesn't matter who they are. Doesn't matter much who the judge is. Because if the charge is different from the evidence, you don't have a conviction. It's very difficult to have a conviction if the charge doesn't fit the evidence. And that's pretty much all I want to say. I hope that helps somebody. If you like what we're talking about here, we'll be back and we'll have some more conversation. And in a couple days, we'll be talking about some more things that are similar to this to kind of help move some people forward, help you decide to do some research on your own. I'm Gary, and if you like this, hit the like button and share. Thank you very much.